From the Osborne Association, Elizabeth Gaynes, President and CEO. Thank you for your patience. We've got you placed here because from an earlier conversation, I had presumed that you would want to talk about, you provide testimony for both topical areas. So this is truly a last but not least. And from my time on the Parole Board and in my current position, I'm certainly aware of the work the Osborne Association does. And I know you do good work in the community against incredible odds. And so I just want to acknowledge that and thank you for that.
Well, I won't say a lot about the election because I think you just heard a lot. I don't think people should ever have their voting rights taken away. Many states and most countries don't. And to me, it's the obligation of a citizen to vote. And I'm more concerned, frankly, with how few people on parole registered and voted than about anything else in that process. But I also realize when I try to go pick up my 8-year-old granddaughter at her school, I need to produce ID, do all of those kinds of things. And so to me, I agree with the idea of having anybody walking in there. So, but I would like to see us, and by the way, the people that were given permission to vote were told to vote between 7 and 9 p.m. There are generally not students there at that time. So I think going forward it does not have to continue to be an issue. I'm obviously more concerned about the other points, and so not burdening you with what I have in my testimony because I'm sure you'll be up all night reading it. So I want to focus on a couple of things. One, particularly things that were said that I think are not accurate. Certainly now, I know Mr. Ferguson hasn't been there for a while. He seemed concerned that the compass was controlling. I also have issues with algorithmic risk scores, but the reality is that the Parole Board, as far as I can tell, would be releasing many more people if they were taking it into account. Virtually all of the we have a program called Elder Reentry Initiative for older adults in the prison system, and many of them are there for years and years. That's how they got to be old in the system, serving life sentences on serious cases, and most all of them have very low risk scores on Compass, and most of them are not being released. So the notion that it's controlling anything, or that it's that much work for the deciders to have to explain why they departed from it. I have probably read 1,000 decisions and 1,000 transcripts over the course of the last few years. It is gratifying that more recently parole commissioners have been actually giving people an opportunity to speak about what they've accomplished, to really talk about what it meant for them to take responsibility and express their remorse and their efforts at doing that. In the past, generally, and particularly Commissioner Ferguson, started with the crime and spoke about and gave very little room to speak about anything else. It is a departure with the new regulations that people are being asked about what they've accomplished in prison. I saw somewhere where parole commissioners actually asked people, tell me what you're proud of. It's a way of, one, putting people at ease so that they can share, which is really important because this video conferencing business as a way of doing parole hearings, which I guess they don't have much choice with not a fully staffed board, it's terrible. As I said in my granddaughter thinks I'm a monster on FaceTime. So I can sort of imagine what this is like, and then remember that most of these older folks in prison who are now in front of this screen, they went to prison before there were these things. They don't get the technology, they're terrified by it. We had a guy who was denied parole because he seemed aggressive in the hearing over the board. It was because they had pushed him, he was typically in a bed, and they had put him in this chair that had him sort of forward, and how he looked to the parole commissioners was like this. Plus he had like a Tourette's, and he kept going like this. And there was nothing in the record that explained that his health was such that, of course, he looked like it was terrifying. In that particular case, and I really credit this, the council through the Parole Board, we've been able to point out that when people with disabilities are going before the board, that they are entitled to a reasonable accommodation, which sometimes includes having a social worker putting them on the calendar earlier in the morning, giving them some extra time. But mostly, the board actually isn't even aware of the fact that this person has a cognitive impairment or some of those other things. We're focused on this because we're working mostly with the older adults. And it's sort of in the file there somewhere, but it's not noted. And I know, Senator Gallivan, you could remember this. It's like there's a million pieces of paper there, and it doesn't exactly come to the top.
Not quite a million, but a lot.
Yeah, it was a lot. It was a lot. And certainly for the ones we're talking about, the older adults who've been in for 25, 30 years, and look, nobody's in for 30 years for singing too loud in church. These are tough cases. And I appreciate this notion about, what the victims are given as an opportunity. But first of all, we should be talking to the DAs because they're making agreements on pleas which allow people to go to the board, but they do not explain to victims. They say, oh, I got you a life sentence. I got you 25 years. And they are actually not explaining that what I really did was I got this guy who's going to be able to go legally, is entitled to be considered for release, and if he meets the standards, will be released after 5 or 12 or whatever that number is. And then victims are numbed and surprised and angry because this seems to be news to them that now they think the person's being released early. Person's not being released early. That was the sentence. And if the board is doing its job and considers whether the person has met those requirements, that's the sentence. A lot of what I heard today makes it seem like the parole board is allowed to resentence people. It is not. There's a reason why the regulations say what they are. And by the way, I do not think that Mr. Ferguson is correct that the information is not available. We get this information routinely about releases and things like that, and I'm sure you could too. It's also not true that the victims and the DAs and the judges are not notified. They actually are. My goddaughter works for the Manhattan DA's office, and she seems to spend her life being assigned to write letters every time somebody from that office is up for parole, and they are given an opportunity to weigh in. She says sometimes in cases that happened before she was born. And I have a colleague who was chief assistant in that office for many years, and I said, Leroy, before you write these letters opposing parole for people that you have had no contact with for 20 years, don't you think you should find out what they've done in that time? Because you seems like you always send this same letter opposing parole. And he said, no, Liz, we have 2 letters, one to oppose and one to strongly oppose. And so you can imagine that sometimes the parole board isn't taking it as seriously as it might because they're getting boilerplate letters opposing parole in virtually every case. The judge is also entitled, but of course for some of these cases where you're talking about 20 years, those judges may no longer be sitting. Not only are the victims being notified prior to a parole, we recently had a participant in one of our programs, a man I have known personally for 15 years because he worked for Osborne in Sing Sing, and we worked with his son, who we now have proudly in college. This man did everything one could expect anybody to do, major transformation of his life. Went to the parole board, he was granted parole, and then it turns out that the letter to the victim in that case hadn't arrived. So the victim then said no, and so his parole was rescinded. The victim was given an opportunity to then make a statement, and I am sad to say that subsequently his parole was denied for 2 more years, obviously based solely on this one new factor, which was the victim, who would have been notified, but because it was 20 years ago or 25 years ago, it took a while for it to get rooted. The thing that disturbs me, though, about the victim component of it is we're using them. Victims, we did not wait until Osama bin Laden was caught before we did everything for those people victimized on 9/11. We did and should have provided them with counseling, with medical care, with financial support. What we do now for most victims is we offer them jail for the person who did it. And if that's all we're going to tell them is our response to their pain is we're going to put this guy in prison and then leave them to believe that that's how that's their healing process, well, no wonder people are angry 20 years later. When I hear, it makes me so sad to hear a widow saying 20 years later, every day I have to relive this. I'm not saying pain goes away. Many of us have experienced loss. But I keep wanting to know, and I want to ask Patrick Lynch, what are you doing for these folks? Like, from day one, what are you doing? Other than parading them back and making a big tzimmus over this. And particularly what concerns me on that particular testimony about wanting fairness. If Mr. Lynch wants fairness, he cannot say that no one convicted of killing an officer should ever be released. Fairness would require considering release. There's nothing fair about saying automatically must be denied. That's not a hearing. That's a resentencing. And you know that of those older folks, people who've done long time, we know that the recidivism rate is close to 0. And so it's not about public safety. And I don't know if you remember this because you were there when I went with a couple of people who were on life parole and a couple of former parole commissioners. And we met with the board, and you were there. And the former commissioners were saying, there's no threat to the issue we raised with you actually was whether people on life parole could get off parole, which you, I think, were supportive of. And I know your record, and you've been supportive of a lot of people, Jerome Wright and other folks that have been, part of you. So I'm not conflating things here. But at that moment, when we said, and the commissioners said, this isn't, there's no public safety challenge here. Mr. Ortloff said, this isn't about public safety. It's about punishment. And that's the remaining concern that I have about much of what I heard today, which was not about following the law. It was about a resentencing, a rule of law. Believe me, I never thought I'd spend my life defending FBI agents and parole commissioners. But in this, there's one decision that has triggered this entire kerfuffle, one person, and then going after the 2 commissioners who voted to release him, putting targets on their back, ending up with them having death threats. Mr. Ferguson made a very good point about wanting parole commissioners who had a certain kind of background. The guy on the parole board who denies parole to everybody, Mark Coppola, is a real estate agent with no background in criminal justice. The 2 people who voted to release Mr. Bell, one of them was assistant commissioner at the Department of Corrections and a crime survivor, and the other one was a parole officer. And not an easy parole officer. I know this because he supervised, when Otis Cruz was a parole officer, he supervised some of the staff at Osborne because we like to hire people who've done these long sentences because they're credible messengers, they're role models in the community. They've learned, they've developed, they've grown. You could not have had 2 commissioners who were better prepared to actually judge the case in front of them. And you may notice that they didn't exactly come to a decision the day of the hearing. They must have, I don't know, and I had never met Mr. Bell and wasn't involved in that case other than writing our standard reasonable assurance letter. But I'll bet you there were 8 boxes of files that they went through. and the courage that it must take, knowing that, I mean, Mr. Ferguson said it, and it was obvious with Mr. Lynch. Those unions put huge pressure on parole board members. They are terrified to make those decisions. So to me, rule of law means that we should be, when people who've been vetted and confirmed by you and investigated up the wazoo before they get to serve on the parole board, make that decision. I believe that they deserve, by the Senate and the legislature and the governor, should have supported them, saying they were the ones who were looking at all that information. They're the ones that read the victim impact statements, they read the sentencing minutes, they read everything. Look, I don't know what I would have done had I been a parole commissioner, or what others would have done. If anybody says that they for sure know that automatically, based on that, without reading that information, without interviewing Mr. Bell, what they would have voted, that's not fairness. That's prejudging something. And part of what we heard today was that's not what we're supposed to be doing. We're supposed to be giving people a fair, not a resentencing, following the regulations as they exist, and making those considerations. So somebody thought the police should have an impact based on arrests that they made 20 years ago. I know you were a sheriff. I know I used to work in Buffalo for a brilliant lawyer, Judge Vinnie Doyle, and I know his sons, and they were sheriffs. I don't think any of them would have said, gee, I want to be deciding after a DA, defense lawyer, and a judge make a deal in a case, or there's a trial and then there's a sentence. Particularly, there are people that are sentenced to less than 25 to life, 19 to life. It's a guy that came to work, has worked for us. We worked inside because he was, the victim was an off-duty police officer. Samuel Hamilton was a lookout. The judge gave him 19 to life at age 19 because he said, I believe this guy is redeemable. And then the police unions came and he went 19, 21, 23. He was 50 years old by the time he was released, even though the judge had indicated, I think this is a redeemable person. But according to the fairness that the union said, one, they should be able to put pressure on board members, and two, he should have never been released. Since he's been released, he works for Bronx Defenders, he gets up in the morning, he's serving people. People are redeemable, and I know that you know that, Senator Galvan. I don't know you so well. I assume you were good people. We know that people can change.
He is.
And so one is, I think you should put pressure on the DAs to stop misusing victims and misinforming them about the future. I think we need to offer victims a lot more than incarceration. I've got data in my testimony. Victims actually want more. They do want restorative practices. They want to see rehabilitation. We have a program with guys who, just homicide cases, called Coming to Terms, where they begin to talk about their lives and the crime that they committed. And we bring in someone who's a survivor, whose sister was murdered by a serial killer. But they start by talking about their own lives. You know, the first time we did this class with 12 men, first one said, and we asked about their early lives, the first one had seen his mother murdered in front of him when he was 3 years old. Do you know what services and support he got? Nothing. He went into foster care, he was abused by a foster parent, and then, yes, down the road, he committed a homicide, and he was sentenced for it. But we can't just think of the victim of the crime he committed. He was also a victim. Every single one of the men in that class had been exposed to serious violence, had either witnessed it, had a family member murdered in their early lives. And if we don't push this support for victims earlier on, well, this is what we know. Hurt people hurt people. We know this is going to happen. So I really appreciate all of the work that you guys do going forward to make this a fairer process. But please don't roll back all the reforms and the efforts that are being made by the board now because of one case that people disagree with. Thank you.
Thank you. I would agree that one case started a tremendous amount of focus on the parole board. I'd suggest, though, and I want to ask you about this, that while some of their decision, well, all of their decisions, they have to make subjective decisions based on where they came from, according to the law. And from my experience, and from where I sit now, and from my experience, no question, they're difficult, especially in the tougher cases, the violent crime cases. But nonetheless, I've always thought when I was there and now, in my advice to the commissioners as we interview them, when they come through the committee, is follow the law. Forget whatever bias you might have about this or that or the other, and follow the law. And clearly, people are going to disagree in some cases. In some cases, I don't think they did, and that's where I'm coming from on it. And my effort is for them to follow the law. You talked about something, I forget exactly how you said it, but if somebody holds somebody 100% of the time, they're the same as somebody releasing somebody 100% of the time. They're not doing their job. And part of it, I think, is part of where we go from here is some things I think the best pursuit is in changing the law. And so to deprecate the seriousness that's translated into the community standard, some people think it should exist, some people think it shouldn't exist. But anyway, I'm kind of moving off of where I started. But the concern, when I made the comment that shedding a light on them, I think, is a good thing, what I think has been consistent from whether it's law enforcement, whether it's very conservative people, whether it's very liberal people, whether it's inmate advocates or whatever it might be, and you just briefly mentioned it at the beginning of your written testimony, is the transparency, and we've got something there that the collective we are raising questions, despite the differences of opinion. And I know in your recommendation, the digitizing some things, making more information available to the public, making more information available to people, probably answers a lot of questions. The release rates, I think, I don't know if this is what you meant when you talked about Commissioner Ferguson about the not getting the information about the releases. He might have said it in a couple areas, but the one that I took, and my experience was always the same, I would have liked to have, as a commissioner, information on what happened to the person that was held or released.
Yes.
And and it's available, you can chase it down, they have all the data, but it never comes together on one report, so you can't even foil it because it's not kept in a report. But that's something that could help to guide the commissioners as, so I guess my point being, then I want to come back to transparency and give you a chance to comment, is there are a lot of concerns that people have regardless of where they come from about the parole board, and I think for all of us, they start at the transparency part before we even disagree. But I guess the transparency is to what extent. So, from your perspective, do you have any thoughts about that transparency part of it and what recommendations you can make?
Well, certainly,
certainly
I would love to see commissioners get feedback because I think people would release, frankly, more people if they saw how well people that they took, because I know it concerns them. I know that there are people that always want to hold, they may not turn down parole for everyone, but certain categories, like, they're never going to release a drunk driver, or they're never going to release certain cases. I don't know that there are any who release everyone, and if you had a full parole board and you had 3 people making these decisions, then even if you had someone who was, in your view, too far one way or the other, there would be 2 other people. So having 3 makes sense. Having it be in person makes sense, so that you really get more of a feel for the person and not a 20-minute video. And then not being able to really look at the records because of the way they are. But when you go to transparency versus this idea that a victim should be able to appeal a decision, our legal system is the people of the state of New York versus Patrick Gallivan. never going to happen. But the point is, victims are represented by the state, and in this case, by the Parole Board. We don't have a system of frontier justice, of people being able to control that process. And that's a good thing. And that's what I said, is if we should give victims a platform, we should give them support, but saying that they could control the outcome, particularly the non-victim representatives, to say, that makes no sense. But in terms of the information being available, I'm not sure exactly which information. I understand, for instance.
That's why I asked.
Well, one thing is we think that victims should be given much more information about what the person did while incarcerated. Because one of the things that I know from talking to the victims people is that they very often ask, well, what did this person do? Like, there's an apology bank, do you know that?
No.
So it's illegal for an incarcerated person to contact the victim directly. No matter how much they want to apologize, no matter how much they've come to understand the impact of what they did. But they can write an apology letter that goes to a website that DOCS has called the Apology Bank. And so if a victim wants to see if someone has posted something there, they can. They have a way of doing that, and it's a safe way for them to be able to get that. Because in the programs we do, most of the people we've worked with, by the time they go through this process of actually beginning to understand the harm that they've caused, because when you've really hurt somebody, you don't really want to face it. And people in prison nobody ever asks you when you're in, by the way, why are you here? There's no work directly on coming to terms with the crimes that they've committed. And nobody feels good about harming another person. So part of this process we go through is for them to actually get to this place like, oh my God, how do I make amends? How do I apologize? Whether it results in their release or not is not necessarily the point. So I do think that very often victims want to know and should be able to know, as should the DAs writing the letters as well. Did this guy go to the yard every day and do nothing and basically not participate? Or did this guy go from having a 5th grade education when he came to prison, and then he went and got his GED, and then he went to college, and now he's part of this youth program where people come in and being able to talk to young people about why? I mean, you'll notice corrections people are not lined up here saying don't release these folks. The only reason corrections people don't want lifers out is because they're depending on them to run all the programs in the prisons, because they have so transformed their lives that they are leaders inside. That's why you'll see, if they would allow corrections people to write letters in support of people coming on parole, you would see a lot of them. I was just did a tour of Sing Sing the other day, and the correction officer was pointing to some guys who've been there for 20 years. He goes, what is he doing here? These guys have master's degrees. So it's right to give victims that information. They would want to know, did this guy just do nothing and get in trouble the whole time and doesn't give a rat's ass, frankly, about what he did to me? Or has he been doing all this work trying to atone for that? So I think that's one part of transparency. I also think that the people the people coming up for parole would benefit from knowing a little bit more about what's in their files, because they can't, they don't share with them their pre-sentence reports from years ago. So they may not necessarily know, unless they're defense lawyers, and defense lawyers are as bad as prosecutors in terms of telling people what the impact of sentencing is. They may not know how to contradict something that's in the record that might be incorrect. So they don't necessarily know what the Parole Board is looking at. There may be other kinds of information like that. So I think that there's transparency would be good at many levels. I think the parole commissioners clearly should be able to see things. Victims probably should be able to see more. And definitely the outcomes. I know, a couple of times, I know Mr. Ferguson said there's no training, but we've actually, several organizations I know have gone to meetings of the Parole Board and brought lots of information. We did things about geriatrics, because I know they're seeing older people, medical. A lot of people have provided that, and at every one of those meetings, the chair would read a letter that she would have gotten from somebody who was released on parole, saying all the things that they had done since they were released. And I think she did that as just a proxy for being able to give people some encouragement for the fact that very often when you finally release somebody, they really have turned their lives around. So I don't know what other information you think, but as long as we haven't, please put money in the budget to digitize those records. It's insane. Do you know that these poor commissioners have to go to Buffalo, even just do a video conference if they live in New York City, because there's only one copy of the paper? Like, that's crazy.
Well, I think they do that for more than just that reason.
Oh, because
But
they just love being together?
No, I think it has to do with the randomness of assignments
No, it's true.
and, who is being interviewed and where, and ensuring some type of rotation so it's not regular.
No, I don't mean just go to the closest place. What I mean is if we had electronic records, then 3 people could be in 3 different places.
Exactly. No, your point is extremely well taken, but I don't think that's the only reason that they go. But we would have to enhance technology. And the other thing I would say about the budget, excellent point, budget process does start with the executive. And to date, or at least in my time in the Senate and this committee, we haven't seen any the governor's presentation of the budget, anything like that included in there. It can start with us.
So if we put forward a proposal, a bill that says that there should be full funding to fully staff 19 parole board members, and by the way, could you digitize the records, we could get some support from the legislature.
Well, let's just go one at a time.
I'll ask the governor first.
That'd be good, but as far as the 12 sitting out of 19, we haven't had a nomination from the executive's office since June of 2017.
I'll get to work on that.
So,
Yes.
now, I guess.
I wasn't blaming you for not putting the names forward. I was just saying is I think it would make a big difference to have a fully staffed.
I'm not throwing it, I'm not just completely shirking our responsibility.
And the governor should be putting names forward.
Both of us can do it, but the budget process does start with him. Both of us can attempt to do it, as you know. So I didn't want to completely,
Well,
when
I
it
will
comes to the
talk to
budget,
them.
say it's all
But
him. It
I'm
isn't.
still going to come back to you about opening an office in Western New York and asking the Senate and the Assembly to help if the governor doesn't.
We can meet separately about that. I have had that conversation, though. Not with you, but with
Denise,
people out
I know.
there.
Okay,
Senator, thank you very much for your patience and your time again,
thank you.
and the work that you do.
Thanks.
I guess it wasn't so bad after all.